Hello, I am Jacob Stein. I'm an asset protection attorney in Los Angeles, California. And this is a quick and to-the-point video on the laws of fraudulent transfers. In asset protection planning, the laws of fraudulent transfers play a singular importance. Let me explain why. So the goal of every asset protection structure is to make it more difficult and more expensive for a creditor to come after your assets. And we commonly accomplish that by taking assets that you own and making them into assets that you do not own. That's not a difficult thing to do, right? Transfer assets to family members, to charities, to legal entities, to trusts. It is so easy to transfer assets out of our names. So imagine I'm being sued, I anticipate a judgment being entered against me, and I transfer the ownership of my home to my brother. The plaintiff gets a judgment against me, they come to me and say, Jacob, we want your residence. And I say, oh, my residence, the one I live in? I do not own it. Someone else owns it, so you can't take it. Right? If defendants, if debtors were allowed to do that, no plaintiff would ever collect on a judgment. So we have a body of law known as the Fraudulent Transfers Law that prevents defendants and debtors from engaging in last-minute transfers of assets. So let me spend a couple of minutes explaining how fraudulent transfer laws work, and then more importantly, what practical impact they have on your planning. There are two types of fraudulent transfers. There is a transfer with actual intent to hinder, delay, or defraud a creditor. Okay? Actual intent to hinder, delay, or defraud any creditor. And there are constructively fraudulent transfers. So there are two types of fraudulent transfers. So first of all, we need to have a transfer. What's a transfer? Well, if I take my residence and I transfer it to my brother, that's a transfer. Right? If I take cash out of the bank account that I have and put it into an LLC's bank account, that's a transfer. But for the purposes of the fraudulent transfer test, a transfer is defined very broadly. It's anything that the debtor does that makes his assets less attractive to a creditor. So for example, if I own assets already through a limited liability company, and I simply amend the language of the LLC agreement, hoping that it will make it less attractive to a creditor, if in fact I accomplish that goal, and simply amending the LLC makes my assets more difficult to get at, right? They're less attractive to a creditor. That is a transfer. And now we need to test to determine if that's a fraudulent transfer. So the first one is the actual intent to hinder, delay, or defraud any creditor. So this test looks at what was my intent behind the transfer. Why did I transfer my residence to my brother? Why did I transfer assets into an irrevocable trust? Why did I transfer assets to an offshore trust? What was my intent behind the transfer? Was it estate planning, succession planning, business planning, investment diversification, right? Or was it asset protection planning? And the plaintiff, the creditor, has to prove that asset protection planning was the primary reason behind the transfer. It is not sufficient for them to prove that asset protection is one of the goals behind the transfer. It must be the primary one. That's not easy to prove, right? So even when clients engage in asset protection planning last minute, meaning an accident already has taken place, they've already defaulted on a bank loan, right? Something bad has already happened. Does it mean that it's now too late to protect assets? And the answer is maybe, but maybe not. Because by itself, the timing of the transfer may be insufficient to prove that it's a fraudulent transfer. Right? Just because someone was involved in a car accident does not mean that their life comes to a standstill. People still take care of their affairs, they still engage in estate planning and do all sorts of other things. Okay? So the first test is the intent test. The second test is known as the constructively fraudulent transfer. And here we don't care about intent. It does not matter why the debtor transferred his assets. We look at two numbers. One, was this a transfer for less than fair market value? And did the transfer leave the debtor insolvent? So transfer for fair market value means the following. I take my $1 million residence and I transfer it to my brother. How much do I get back from my brother? And if that answer is less than 1 million, it's a transfer for fair market value. Once we have established that the transfer was for less than fair market value, the second part of the test is, am I insolvent? Meaning, do my liabilities exceed my assets? Right? So these are very mechanical accounting kind of tests. We simply look at numbers. Someone is either solvent or insolvent. The transfer was either for fair market value or for less than fair market value. We always want to engage in transfers of assets if we can in exchange for fair market value. Because if the transfer is for fair market value, it knocks out the constructive fraud test, and it makes proving actual intent to hinder or delay the fraud so much more difficult for a creditor. But let's assume that it is possible that the creditor can argue that the transfer we are engaging in is a fraudulent transfer. What should we do? Well, first of all, in many cases, we do not know in advance if a transfer will be a fraudulent transfer, right? Because it's only a fraudulent transfer if the judge rules that it is, right? So nothing is a fraudulent transfer in and of itself. It first has to be challenged as a fraudulent transfer, and then the judge has to rule so. So the analysis is engaged in retrospect, right? So today, it's a transfer. How it will be classified later, we do not always know. But what does it mean? Does it mean you don't do anything if there's a possibility of a fraudulent transfer? I'll give you a recent client example. My client, she was in her early 70s, and she guaranteed a loan that her son took out. She guaranteed approximately a $5 million loan. Her son took the money from the bank to develop real estate. Took him a couple of years to fail in all of his projects. Everything is upside down. He walks away. He has no assets. He walks away. So mom is left sitting and holding a $5 million personal guarantee. What should she do? So this $5 million guarantee will completely wipe her out. She has a little bit less than $5 million of assets, of net worth. She has two simple options. A, she can choose to do nothing, which I think a lot of lawyers would recommend because they would be afraid that doing something that late in the game would be a fraudulent transfer. And they say, do nothing. Option B, do something to protect assets. How will that work out? If she chooses to do nothing, which by the way is really simple to implement, right? But if she chooses to do nothing, what are the odds that the bank will reach her assets? The answer is about 100%. There's about a 100% chance, give or take like zero, that the bank will reach and take away from her everything that she has. And at 70 years of age, she will be left only with her Social Security check. Right? That's option one. Option two, let's do something to protect assets. And if we do something to protect assets, maybe the creditor will challenge that as a fraudulent transfer. Maybe, because they do not challenge every single transfer. And if they challenge the transfer as a fraudulent transfer, maybe they will be successful, right? Because they're not successful 100% of the time. And even if they are successful, what happens? Well, the remedy for a fraudulent transfer is to unwind the transfer, to recover the transferred asset. So what's the downside of option two? For her, even the legal fees are not a downside because she would have lost everything. Option one, 100% chance you will lose everything that you have. Option two, some percent chance that you get to keep some or all of your assets. As Wayne Gretzky used to say, 100% of the shots you do not take do not go in. And this is exactly the same logic here. So in this example, this woman managed to keep all of her assets because when the bank saw the asset protection structure we set up for her, they decided to walk away. They decided not to pursue it. It's a wonderful result. It's not a result we can promise a guarantee in every case, but we can guarantee that if she did not try to protect her assets, this result would be impossible. So while we should always avoid engaging in a fraudulent transfer, from a practical standpoint, if we are not certain how this transfer will play out, we should consider transferring the assets to protect the client's net worth. I am Jacob Stein, and I hope you've enjoyed this presentation on fraudulent transfer laws. Thank you.